Sorry for the delay. We're the rest of my order. Okay. We're good? Good afternoon. My name is Alex Fisher. I'm the chairperson designee of the New York City Loft Board. I'd like to welcome you to our March 17, 2016 public meeting. We first turn to a vote on the minutes from the February 18, 2016 meeting. Are there corrections or comments to the meeting minutes? Yes?
I sent around a note, I think, to everybody expressing my sense that the minutes were lacking some of the relevant portions of the discussion.
So I think the Loft Board's position is that we aren't going to do a word-for-word set of minutes, and to the extent that there is additional information that's not noted in the minutes, we can simply direct people to the video.
Okay, but for example, my suggestion that the board consider a specific idea with regard to a different approach to the narrative statement conference is a pretty substantive point. Not, I certainly agree that the minutes aren't a word-for-word transcript.
So turning to that point, I mean, I think if you want to put that on the agenda for the next meeting, and we can certainly put the item on the agenda, but my perspective is that items that are not on the agenda, at least a week prior to the meeting, are not really up for discussion.
I think you misunderstand my point. I wasn't asking that it be necessarily discussed today. I was asking that it be that point should have been in the minutes.
Mr. Delaney, I gave a great deal of space to the conversation with regard to what you brought up. I didn't put everything in that you said, and I didn't put everything in that everybody else said. If you had a good point, that good point is on the video.
Okay, I would respectfully request that the minutes be amended to include that one point.
There are two ways we can go about this. We can ask the board to vote on the minutes the way they are. And if they want me to amend the minutes to put in this 3 sentences of Mr. Delaney's, then they can defeat the minutes, and then we can have a vote on them as amended. Or we could, either way. That's your call.
I'd like to vote on the minutes as they currently stand.
Well, I think it's a point of order that Chuck to make a motion to amend the minutes and put in his 3 sentences, and then we can then vote that up and down.
That's fine.
If you wanted to get a second.
That's fine. That's exactly right. Thank you.
Okay, I'll be happy to make that motion. I would also just point out, as I stated in my email, that several other board members had made comments, so I'm not necessarily looking for more space necessarily devoted to what I have to say other than that one point. But when I think both Mr. Schachter and Ms. Shelton had made comments, that board members who make comments should have at least the gist of those reflected in the minutes. So I will make a motion for the minutes to be amended.
Okay. Is there a second? Mr. Barowitz, thank you. Board members, please.
Mr. Cover.
Actually, not going to vote on this because that was not here with us on the board.
Mr. Larry.
Yes.
Mr. Gregory.
I just want to be clear that the motion what we're voting on is to accept the minutes as they in their current state.
No, this is a motion to amend the minutes as requested by Mr. Delaney.
No.
Chairperson Fisher.
No.
Mr. Delaney.
Yes.
Mr. Schachter.
Yes.
Ms. Shelton. That's 2 no, 3 in favor, 1 absent, and 1 abstain.
Okay, we're going to table these minutes for the next meeting then. There will be no executive director's report this month. And I just want to repeat what I said to Mr. Delaney earlier. To the extent that any member of the board wants to put something on the agenda for discussion, please send an email to my attention at the buildings department, and I will consider it accordingly. At least a week prior to the meeting would be appreciated. Well,
There's no executive director report, even though it's on the agenda.
yes.
Right, I got sick.
I hope you're feeling better.
I'm not really, thank you.
With regard to my request, which was not made in writing, but was made at the board last month, that we could hope to get some additional clarity from the Department of Buildings regarding its approach to an inspection. I assumed that would be touched on in the executive director's report, and I was also hoping to learn a little bit more about this notice to all loft owners and tenants that was circulated yesterday.
I met with the Department of Buildings on several occasions to discuss the issue of these heaters. It was determined by Ms. Fisher and I, after having these conversations, that the best way to handle the situation, which would benefit the safety of the tenants while still not acting in a way that was going to displace them or harm them, was to ask the owners to please go through their units, and if they have these units, to have them inspected by a master plumber and to put in the CO2 detectors. The one thing that we did not want to do was to cause DOB to go into every one of our buildings, because we knew that they, once they saw them, would have to act. They're particularly sensitive now to gas issues, having had the explosion on 2nd Avenue. And so we have done that. We've also discussed this with a number of owners, lawyers, architects, etc. We have discussed actually what you had suggested, which was that if an owner can do the work for the heaters prior to the certification of the remaining part of the narrative statement conference, we will try to help them do that, provided it does not unduly make it difficult for the tenants. So that is certainly an option. What we have stressed to all of the architects that are that we know practice in front of us is that we want to try to use the time well and get as many of the new buildings through the narrative statement process as quickly as we can, so that this work can be done. We don't anticipate that the work will be done by the beginning of next heating season, but we would like to shoot for that as much as possible. So that's what I have to tell you.
Okay, and thank you, and I don't want to tax your voice any more than necessary, but just as I read this, I take it that there is a carbon monoxide detector specifically designed to be used in conjunction with these heaters, that, as opposed to just the carbon monoxide detector you get at Home Depot.
We did not want to suggest a particular type of CO2. There is a problem that I'm not completely 100% sure about this, but if you are going to do some work that requires, we would love to have a CO2 detector that's hardwired in there and shuts it off. We'd like a lot of things, but one of the problems is if you have to get a permit to do this work, well, we're happy to help you get the permit. When it's done, DOB goes and inspects. And if DOB goes and inspects your nice CO2 detector and sees that the gas lines are not up to code, they're going to shut down the gas. So we are working a very fine line here, Mr. Delaney. So, we're doing the best we can. And I hope that all of the tenants, we put this letter that they're discussing on our website. We've sent the letter to all of the architects, the owners' council, and all of the tenants' council, so that everybody is aware of the issue. If the owners are not going into your units, tenants, and you have this type of heater, you should start contacting your owner and finding out when they're going to be doing the inspections to make sure that your pipe connections are proper. So, you know, we've lived with this for 30 years. We had problems with it. We know that somebody was killed with carbon monoxide many years ago. We're aware of it. We, again, walk a very fine line between protecting the tenants' right to live in their units while construction is being done and calling attention to certain substandard conditions when it's brought to our attention. We usually do not call in DOB unless it's something that is particularly sensitive, like there's a building that's going to, its foundation is unsteady, it's got to be braced up. We'll bring in DOB, things like that. For the most part, we've tried to keep DOB from our buildings. This is a very difficult situation for DOB and for us, and for fire, all right? So we're doing the best we can, and I hope that that's sufficient for you, Mr. Chairman.
My understanding from personal experience in other loft buildings, it's Con Edison that turns off the gas, not DOB.
No, DOB calls in Con Ed. DOB calls in National Grid. National Grid's in Brooklyn. Okay, so when DOB sees this, they call in the gas company and they have them cap it. If the gas company will not come, they vacate. Okay? If the gas company comes and says, I'm not going to turn off the gas, they vacate.
Okay.
And please try to remember that this does not just involve the tenant's heat. It involves their hot water, and in many cases, their ability to cook. Because they have gas stoves, some people have gas dryers. Okay? So we have all of that functioning in these units. We're going to try to, as expeditiously as we can, address the 82 units that we have now in our narrative statement process with regard to the new buildings, and the 25 buildings that we have currently from the old buildings that have either finished the narrative statement process and have not gotten their permits or are still in the narrative statement process. With the old buildings, every unit, every building except one, and that building was illegally converted back to commercial, that's a different issue. But every other one of the buildings has filed their Alt 1 and is either in the narrative statement process, finished with the narrative statement process, and have obtained permits. And as a matter of fact, more than half of the remaining 281 buildings have gotten a C of O, a TCO, or 7B compliance, which means that they are all fire safe. So more than half of the old buildings are now fire safe.
What I would like to know and find out is the potential risk of using up the oxygen because the flame is on. And two, the flame goes off and carbon monoxide.
That's why we asked them to put in a carbon monoxide
I
detector.
understand, but
I mean, you know.
No, but what I would like to know from an expert is what are the risks and what are the chances? When I was reading this, what I was surprised is that in commercial spaces, you can have these overhead gas heaters and they're legal.
The problem with these,
Where the potential of disruption could be far greater if a half a dozen or a couple of dozen people are in the store.
No.
And this thing goes.
no, that's not what this is about, Mr. Barrett. If you are in a manufacturing area with a Modine heater, a direct vent heater, it's a large open space, generally speaking, and it has been appropriately installed. What we have here is some of them may be perfectly fine. They were appropriately installed and they were appropriately placed in a 4,000 square foot open loft space. In some cases, though, these Modine heaters are put in bedrooms where or they were installed without a permit, maybe by the tenant, but certainly in many instances not by a master plumber. Those are the ones that we are concerned about. Okay? So by and large, modine heaters are fine in a manufacturing setting. They are not fine in a residential setting with enclosed rooms.
No, I perfectly agree and understand that it shouldn't be in a bathroom or a bed. I have no question about that. You know, but I just have this broader question, is if they are fine in an open space, right, then there shouldn't be a whole lot of question about what's legal and what's illegal. The fact is that they're illegal in a bedroom and a bathroom, perfectly understandable, and that has to be remedied. But if they are indeed, I mean, I didn't know how to read that report that came from the Department of Buildings when they said it's legal in a store or in a factory space. But then it also said it's not legal in law. But if a carbon monoxide unit is installed, then it's okay. Now, did I read that incorrectly?
Mr. Delaney, I mean, Mr. Barrow is
Oh,
on.
right.
And you know why.
Sorry, what report are you talking about?
That thing that we got 2 paragraphs.
Oh, you mean this?
It
The
was
letter.
the letter.
Ah,
The letter just says that they are okay, that they're not, the building code does not permit these types of heaters in a residential apartment, in a residential unit. That's it. The building code does not permit it. End of story. It is not a residentially acceptable in a residential unit.
Well, that's what
We know that they will all be removed because during the legalization, they must be removed. Okay? In the interim, which is what we are, interim multiple dwellings, we are trying to make sure that nothing bad happens. As I said, many of these units are probably fine. They're installed properly, the gas piping is fine, they're not in a bedroom or an enclosed area, it's fine. It's the ones that are the problem that we want the owners to go in and monitor. And if the owner doesn't go in willingly, we hope that the tenants will request that they do so. We don't want to have to send DOB in to 331 buildings with the end result that where they find a modine heater, they're going to cut off the gas. This was the best way to go.
Okay, no problem.
I'm sorry, I just need to go back to my question. I got a lot of answer, but there's a piece that's missing. And without going into brands, do we believe that there is a device that's designed to both detect carbon monoxide and be able to shut down a modine
Mr.
heater?
Flanagan, I did address that. I said there is such a device, but if that device requires that the DOB inspect it once it's installed, we do not necessarily recommend that it be installed unless somebody is damn sure that the pipes are okay. Okay?
Okay, fine. And then my only other point, you mentioned that you've identified 82 units?
There are 82 IMD buildings.
Buildings, oh, okay.
From 281.5 that are in some form of the narrative statement process that have not gotten their permits.
Okay, so...
But when we're talking about the 281.1 buildings, for the most part, they have, more than half of them are fire safe. All but 25 have gotten their plans, through and we're in the narrative statement process. 25. We got another one. Yes. Terrific. 25.
Okay.
That's all that's
Got it,
left.
okay.
Okay?
So that's not an identification of units?
No, we're not, we don't.
Fine, thank you.
That's the building, but
That's
Got
the
it.
inventory
Got it.
of buildings, not units. Mr. Shacker, did you want to ask me a question?
Yes, please. And
First, I want to thank you for sending this out before the meeting so we could look at it and of course, take action to address the risks that we discussed at the last meeting. I know that sometimes there are points that there are questions and discussions that are not necessarily appropriate for the public, so therefore, if this is something that would be best addressed in an executive session at the end of the meeting, that's fine, or not, as you may prefer. I was just wanted to ask about, as you said, this is a balancing act of various different priorities and trying to address risks to the most beneficial outcome possible. One of the questions is the last sentence: should the owner fail to take these recommended measures, we urge each tenant to contact us. And you've been very clear about sort of what the risks and the downsides when sort of destroying the village and save it kind of situation where DOB staff are compelled to shut off, to request the shut off of gas. So I don't know if you're comfortable talking about this now or talk about later about sort of in such a scenario, do we ever thought about how the law court would handle such a contact by a tenant who says, okay, it's going to be a case by case. Okay. It also probably perhaps contextualize, as you were describing before, the particulars of the loft space in which they're located.
That's right. And let's remember that we're bringing in all of these tenants for narrative statement conferences. These issues will be addressed there, but not in such great specifics. Okay. We do know that heaters are replaced. We do not generally, we're not informed as to what heaters are being removed or what the current heat is during the narrative statement. Okay. But if the owner's architect comes into us and says, we want to do the heating work right away, we think it's urgent, and we have a plan, we'll bring in the parties, and we will try to expedite that, all right, without going any further, okay? Anything else? Okay.
Great. Thank you. Turning now to our cases. We have one administrative appeal and two reconsideration cases. The first case is the appeal. KNC 2 LLC 235-241 Berry Street, Brooklyn, AB 0078. Bruce, please present the case.
On September 30th, 2015, the owner filed this appeal to challenge an administrative determination which denied the owner's application for an extension of the deadlines for Article 7B and obtaining a C of O. The determination denied the application as untimely. Section 201B1 of the Loft rules requires that an application for an extension of the code compliance deadline be filed before the deadline. There are two exceptions to this time limitation, and neither one applies in this case. The owner is not a new owner, as that term is defined in the Loft rules, and the building was an IMD for more than 90 days prior to the filing of the extension application. The building entered the Loft Board's jurisdiction 5 days before the expiration of the application deadline and 3 months prior to the permit deadline. Yet at the time, the owner did not request an extension of these deadlines. By the time the owner obtained its permit on October 30th of 2015, all of the code compliance deadlines had expired. Despite the fact that the owner is out of compliance with the legalization timetable, the owner argues here that it had 18 months from when it finally obtained the permit to achieve Article 7B compliance. Owner's interpretation would render the legalization timetable meaningless. For example, an owner could go years without filing an alteration application or obtaining a permit to do the legalization work, and according to the owner's interpretation, would still not be out of compliance with the 7B deadline. The owner's interpretation will provide an owner with an automatic 18-month extension to achieve Article 7B compliance upon the issuance of the permit without regard to whether the owner obtained the permit within the statutory time frame. To To adopt this interpretation would reward an owner for non-compliance with the legalization timetable. Further, in January of 2014, in the matter of Stone, a case provided to you in your backup, the Loft Board rejected exactly this argument. The staff recommends that the appeal be denied.
Thank you. Comments or questions on this case? And a motion to accept this case.
Mr. Chair.
Mr. Schechter, thank you. Is there a second? Mr. Gregory, thank you. Would you poll the members, please?
Mr. Carver,
Yes.
Mr. Barrett,
Yes.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Mr. Schechter.
Yes.
6 in favor, 2 absent.
The second case is a reconsideration case. It is Muriel Gold, 247-249 West 16th Street, R0343. Ms. Cruz, would you please present this case?
On December 28, 2015, the owner of the building filed a reconsideration application seeking review of Loft Board Order
Very
44.
difficult to hear what people are saying. Could they pull the mics down or turn the sound up? I think a lot of people can.
On December 28, 2015, is that better?
Yeah.
Okay. The owner of the building filed a reconsideration application seeking review of Loft Board Order 4444, which denied an application for Article 7C coverage. The owner alleges in this reconsideration that the Loft Board made an error of law because it failed to consider the owner's argument that a prior net lessee cannot be a protected occupant as a matter of law. The owner does not wish the Loft Board to reconsider the denial of the coverage application, but only seeks that the Loft Board amend the basis for denial to include as an additional basis that Mr. Lerner is not entitled to protected occupant status due to the prior net lease. In this application, the owner is requesting that the Loft Board make a determination that is unnecessary and has no practical effects on the parties. Having found that the building and the unit are not covered, this issue presents a hypothetical question that will have no effect on the parties in this case. The owner is seeking to have the Loft Board render an advisory opinion. This is not a proper basis for reconsideration, and the staff recommends that the board deny the reconsideration.
Thank you. Anyone have any comments or questions on this case?
I was just curious, did they articulate any reason for the reconsideration? Was it like pending litigation or something that helped their case or something? Or just-
Error of law.
Okay. All right.
Any other comments or questions? Is there a motion to accept this case? Mr. Gregory, thank you. Is there a second? Mr. Schechter, thank you. Can you poll the members?
Mr. Carver,
Yes.
Mr. Barrett,
Yes.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Mr. Schechter.
Yes.
6 in favor, 2 absent.
Thank you. The third case is also a reconsideration case. It is Gerald Lerner and Jane Idit, 247-249 West 16th Street, R0344. Present this case.
On December 23 of 2015, the occupants of the third floor filed an application seeking review of Loft Board Order 4444. In this case, the tenants seek reconsideration on all 4 grounds in Section 107 of the Loft Board rules. First, the record shows that the tenants were not denied due process in the coverage case. Tenants participated in the 4-day hearing. Tenants were represented by counsel, presented evidence, cross-examined witnesses, and presented arguments about the relevant law and facts. The parties also submitted post-trial briefs. Judge Casey issued a reported recommendation and referred the matter back to the Loft Board on February 19th of 2015. Nearly a month later, the tenants submitted a motion requesting that the hearing be reopened to introduce evidence not presented previously. Judge Casey denied the motion. Tenants argued that Judge Casey's decision constitutes a denial of due process. Section 107A21 requires that the denial of due process happen in the underlying proceeding. Here it did not. Before Judge Casey, tenants had every opportunity to present the evidence they deemed necessary. By the time they filed the motion, the hearing was over. Judge Casey had already issued his recommendation to the Loft Board. The matter was before the Loft Board for issuance of the final order. Second, there was no error of law in the order. The remedial nature of Article 7C has nothing to do with the reason why the board denied coverage here, nor can it be the reason why coverage is granted. The board denial of coverage is based on the evidence in the record. None of the cases cited require that the law board grant coverage if the record does not support a finding that the eligibility criteria have been met. Tenants had to prove that Mr. Hans, a residentially occupied Unit 3R, on December 1st of 1981, since April 1st of 1980, which both Judge Casey and the law board found they failed to do. Third, the tenants alleged that the law board made an erroneous determination which could not have been anticipated during the hearing. The argument fails because the rule requires that the alleged erroneous determination be based on the ground not argued by the parties in the prior proceeding, and that the parties could not have reasonably anticipated would be the basis for the determination. The record shows that the residential occupancy of Unit 3R was a point of contention throughout the litigation. In its answer, the owner disputed that there were 3 or more families living independently from one another during the window period. At the hearing, the owner was critical of the evidence regarding 3R. The parties also argued the point in their post-trial briefs. Because the parties argued about this issue throughout the case, it should have been anticipated that the evidence regarding the residential occupancy of Unit 3R could be the basis of the determination to deny coverage. Finally, the last basis for reconsideration also fails. The evidence presented in the motion could have been discovered if due diligence had been exercised. The failure to conduct a thorough search of the evidence prior to the hearing does not demonstrate due diligence. The failure to request assistance to secure the evidence needed is also not due diligence. The staff recommends that the law board deny the reconsideration in its entirety.
Thank you. Are there questions or comments on this case?
Can you review for me the interplay between the request to examine this material that was denied first by the oath judge and under oaths rules, and then how that interplays with our rules?
I believe that the oath rule says that if the case has already been transferred to the agency, that the motions had to be made to the agency, which they didn't do. We never received the motion. They did it directly to Judge Casey. Now, our rules say that the case is closed upon the submission of post-trial briefs at the end of the hearing, unless the judge further extends it for submission of other evidence, which didn't happen here. So the record will be closed at the end at the submission of post-trial briefs. So the record that is before the board in this case would be whatever was submitted prior to at the time that the post-trial briefs were submitted.
And as I recall, this case initially turned on this being the third unit, and the alleged occupant of that unit was kind of placed there in the oath proceeding in the months just after April 1st, 1980. Right. But now we're presented with evidence that might be conclusive that the tenant was in place by April 1st, 1980.
I'm not...
The evidence has been submitted.
Evidence has been submitted, yes.
Right, okay. Right. I voted for this case at the time that it was before the board, but I'm going to vote no on denying reconsideration because I have had a long-standing problem with the way oaths rules and our rules play together. And I think in this case, I find that bothersome.
If this was a situation in which I believe that the proposed order says that somehow the tenant was unable to secure the documents without, if he was barred, I believe he says that he couldn't or didn't, the documents were in the storage locations. If he somehow couldn't get to the documents, despite all due diligence, that would be a grounds for reconsideration. And that would be a grounds to consider the evidence. But here, that's not the situation. The situation is that, he had access to his storage locations and just didn't look for it because he didn't think it was relevant. That's not due diligence. So I think that the rules provide for the opportunity for tenants to present evidence if for whatever they couldn't access the information or weren't able to access despite all due diligence. And that's not what the application says here.
Am I correct that they didn't pursue the search for additional information until after the decision was rendered?
Exactly.
Okay. That's what-
Further comments or questions? Mr. Barber?
Yeah, I just had one question. When I was reading this, I was just wondering, when an error of fact becomes an error of law. So I'm wondering if the claim was legal insufficiency of the evidence, would you then consider that to be an error of law? I guess the question is more abstract than, but legal insufficiency is a question of law.
Right.
Okay, all right, thank you.
Additional comments or questions? Is there a motion to accept this case? Mr. Shackman, thank you. Is there a second? Mr. Gregory, thank you. Can you poll the members, please?
Mr. Carver,
Yes?
Mr. Barrett, Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
No.
Mr. Shackman.
Yes.
5 in favor, 1 against, and 2 absent.
Motion carries. We turn next to the summary calendar. There are 9 summary cases. These cases are voted on as a group. They are Courtney Lauren Miller, 57 Thames Street, Brooklyn, PO 0005. Greg Boosted and Katharina Kobitsky, 57 Thames Street, Brooklyn, PO 0019. Nathaniel Ward, 250 Moore Street, Brooklyn, TA 0214. Ethel Kamburian and Mary Grossman, 35 West 19th Street, TH 0198. Gregory Kitchen, 34 West 28th Street, TH 0201. Octavio Molina, Doreen Gallo, and Gail Mariner Smith, 177 Water Street, Brooklyn, TM 0079. Alon Cohen and Patrice Leroux et al. I'm just going to shorten it. 57 J Street, Brooklyn, TM 0081, TM 0083, and TM 0084. Paz Rental LLC, 57 Thames Street, Brooklyn, TR 1210. Annabelle Murillo, Adam Harvey, and Davey Woodward, 107-109 North 1st Street, Brooklyn, TR 1249. Questions or comments about any of these cases? Is there a motion to accept the summary cases? Mr. Barrett, thank you. Is there a second? Mr. Carver, thank you. All the members, please.
Mr. Carver,
Yes?
Mr. Barrett,
Yes.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Mr. Shackman.
Yes.
6 in favor, 2 absent.
Thank you. We now come to the master calendar case calendar. We have one access case. It is 141 Spencer Street, LLC, 141 Spencer Street, Brooklyn, LS 0231. Mrs. Cruz, could you please present this case?
On September 24th, 2015, the owner of the building filed an application seeking an order directing tenants to provide reasonable access to units 201 and 301. In the notice dated December 15th of 2015, Judge Casey declared that occupants of units 201 and 301 in default. The tenants had 30 days to file a motion for relief from the default determination but failed to do so. In the report, Judge Casey recommended that the Loft Board grant the access application. The owner's application alleges that the tenants failed to provide access for legalization work approved by the Department of Buildings and listed on the narrative statement certified by the Loft Board. The record shows that the owner served the proper access notices. The tenant failed to appear in this access case to dispute the allegations or provide a reasonable basis for failing to provide access. Staff recommends that the board grant the application.
Thank you. Are there any questions or comments about this case?
So no one heard anything from the 2 units of tenants ever? Okay.
Anyone else?
Mr. Cover,
Yes?
Mr. Barrett,
Yes.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Mr. Check.
Yes.
6 in favor, 2 absent.
Thank you. This will conclude our March 17th, 2016 Loft Board public meeting. Our next public meeting will be here at Spector Hall, 22 Reed Street, first floor, on April 21st, 2016 at 2 p.m. Board members, please sign and hand in your attendance sheets. Thank you.
Happy St. Patrick's Day, everyone.